Hey guys, welcome to another one of our case decision videos. My name is John Watts. This is a tax court decision, and while we'll go over some details about tax liens and offers and compromise and things like that, what I really want you to see this case for is the concept or the principle that if you're asking somebody for help, then you've got to play by their rules. So if you're going to the IRS and you say, look, I owe you $150,000 in taxes, I admit it, I want you to cut me some slack. And they say, well, here are some forms you have to fill out. Well, you need to fill out the forms. Here's a hearing date that you need to show up for. You need to show up. Here's a deadline. You need to meet the deadline. Same thing with your mortgage company. You ask for loss mitigation help. Give me a loan modification. Give me a deferment. Give me this or that so I don't lose my house to foreclosure. And they say, well, fill out this form. Well, you need to fill it out. And I don't know what actually happened here. All I have is this opinion, but they at least portrayed the taxpayer as not complying with all the requirements. And so I want you to see that. So here's the background. This guy's a lawyer in New York, and the IRS says, hey, you underreported your income. And so they ultimately settled it for these years, 2000, 03, 05, and 06, and there were these deficiencies. They agreed that this is what's owed. And so later the IRS files this NFTL, which go back up here. We see that's the Notice of Federal Tax Lien. And at that point, it was $194,000. And they said, hey, look, you've got till September 22nd to request a CDP hearing. And we've talked about this before. If we go back up, it'll tell us this is a collection due process. And so they say, you've got this time. And petitioner requested the hearing. And he said, look, I can't pay the balance due, so you should withdraw that lien. And what I'm looking for instead is an offer and compromise. And we have a video on that. That's where you say, I admit that I owe this, at least in 2 of the 3 cases. You say, I admit I owe it, but either there's just really exceptional circumstances that you should give me a break, or more likely, I just can't afford it. Now, there is an offer and compromise where there's a doubt to liability, but that's not too commonly used. We've certainly used that before for clients, but it's not the typical thing. So this guy is saying here, look, I want to do an offer and compromise or an installment agreement. So an installment agreement is where there's a certain period of time you're going to make X number of dollars of payments, and generally the idea is you're going to pay the whole amount. Offer and compromise might also be a payment plan of 24 months or 5 months or less. And anyway, he's saying, don't do that notice of the tax lien. Instead, let's do this alternative collection. And so when the IRS receives that request, they assign it to what's called an SO, or settlement officer. And so the SO says, well, look, your hearing request was untimely, but I'm going to give you basically the equivalent of that. And so they review the administrative file and confirm the tax liability has been properly assessed, all the requirements have been met. And then the SO determined that the petitioner, the taxpayer, was not in compliance for 07 to 2012 and 2015. So if we go back up to the facts, let me see if I can find it here. Yeah, so the tax liabilities, we're talking about 2000, 03, 05, and 06. And then there was an amount that was in essence agreed upon. And then in 2016, the IRS says, hey, we're going to do this tax lien. That prompts the taxpayer to go, wait a minute, let's not do that. But then he misses the deadline, according to what we're seeing here. And then the settlement officer says, you're not even in compliance for 07 to 012. And generally on anything you're doing with the IRS, you've got to be in compliance. In other words, you have to have made filed your taxes, and it can vary whether or not you have to be current on all your taxes. But the point is that the settlement officer is saying you're not eligible unless you file the delinquent returns. So what happens next? Well, the settlement officer says, look, we're doing a telephone hearing March 15, and you have until March 8 to submit the 433A form. And this is when we're looking for particularly offer and compromise. So it's all this financial information. And you have to file a form related to your request to draw that notice of filing of the tax lien. Well, what happens? November 15 hearing or March 15 hearing comes along, nobody calls in. So the settlement officer sends them what's called a last chance letter that basically says, I'm not going to reschedule the hearing, but if you will get me the paperwork by March 29, then I'll look at that. The taxpayer does not dispute that they received that letter. Well, they didn't submit anything. But on March 29, which is the deadline, we've got the taxpayer calls the settlement officer and says, well, let me add my lawyer to the call. But they couldn't get the lawyer on the phone. And so nobody, the taxpayer, the lawyer, nobody attempted to contact the settlement officer later that day. So on the 30th, which would be the next day, they closed the case. So April 11th, the IRS issued a decision letter in which it sustained the NFTL filing, so there's going to be a tax lien. And so the court or the taxpayer petitions this court 30 days later, and then we have the respondent, which is the IRS, files an answer and says, all right, the CDP, remember that's the collection due process hearing request, was timely. And so they're arguing about, how should you treat certain things. And so first we start with the jurisdiction. So every federal court this is true of. It's a court of limited jurisdiction. Most state courts, at least there's some state court in your state that is a court of general jurisdiction. And so they say we have to determine whether it's one Congress has authorized us to consider. And so let's look at the rule. Where the IRS Appeals Office issues a notice of determination after a CDP hearing, taxpayers 30 days to petition the court. So we need a valid determination letter, and the taxpayer has to timely petition for review. And so the IRS says, you know what, you have jurisdiction. Okay, so it was a timely request, and while the taxpayer here didn't get the notice of determination, says they inadvertently issued a decision letter instead of a notice of determination, that letter constitutes a determination. So it's kind of like the IRS didn't do it exactly right, but it's good enough. So the court can handle this. So the IRS has asked for summary judgment. Summary judgment's where you say there's no factual disputes, or if there are factual disputes, give the other side the benefit of the doubt. I still win. That's the idea here. So the purpose is to expedite litigation, avoid costly, time-consuming, unnecessary trials. You can do it where there's no genuine issue as to material facts in dispute, and the person moving, or here the IRS moving, is entitled to a decision as a matter of law. So they say we're going to construe factual materials and inferences in the light most favorable to the non-moving party. That would be the taxpayer. But you've got to actually have facts. You can't just rely on what is in your pleadings or where you have made allegations. You have to provide proof. And the court points out that the law doesn't really tell them what the standard of review is. In other words, how should the tax court look at what the IRS did? And they say, but we have case law that tells us what to do. So where the validity of the taxpayer's underlying tax liability is at issue, in other words, do you owe the money or do you not owe the money? The review of the IRS determination is de novo. It means the tax court's going to look at it and just use their own judgment. They say, we don't really care what the IRS found. We're just going to make our own decision. But if the underlying liability is not before us in the tax court, then they review the IRS decision for abuse of discretion only. Well, what is abuse of discretion? Well, it's still kind of a bunch of words, but it's arbitrary, capricious, without sound basis in fact or law. Here's the practical importance of that. The tax court's not going to say, well, what would we have done? oh, we would have done it different, so we're going to overrule the IRS. No, instead they look at it and go, is it so bad what the IRS did that we just can't allow this to stand? So, and I think I used this illustration in another case. It's kind of like in whether, let's take pro football. So looking at an instant replay or, a review, and the guy in the booth may say, I would have said the guy was out of bounds, or I would have said that, he had didn't cross into the end zone, or whatever it might be. But I'm not going to overrule the official on the field who was right there in the heat of the moment, unless it's just really obvious that there's been a mistake made. And so that's what we're looking at here is when you admit that you owe the money, and then you're saying, hey, the IRS messed up by not giving me an offer in compromise, installment agreement, then you've got to really convince that tax court that there was some real bad stuff going on here. So let's look at the analysis. So in determining whether the SO, that's settlement officer, abused his discretion, we look at number one, did he properly verify the requirements of the law? And has that been met? Number two, did the settlement officer consider any relevant issues? And number three, did the settlement officer balance out the need for efficient collection with also the fact that you don't want to just destroy taxpayers, okay, and totally ruin their life? I mean, there's got to be this balance here. And so they say, well, first of all, settlement officer looked at the transcripts to verify liabilities properly assessed, and in the taxpayer's request, checked a box for that tax lien to be withdrawn, but failed to submit any documentation to show that he met any of the categories justifying the withdrawal. So if you don't put the proof forward, you're not going to get a reversal from any court, okay? And then it says, well, the taxpayer says, the settlement officer should have given me a face-to-face hearing. And the regulations say that you can, but you don't have to give a face-to-face hearing. And so the tax court has said, look, we've repeatedly said, you don't have to have face-to-face hearing. It can be by telephone, correspondence, document review. And then the next argument is, well, I would have participated in the hearing and I would have provided the requested financial information, but the settlement officer didn't communicate with my lawyer. And so he says, my lawyer did not receive a copy of the first letter, and that the settlement officer failed to respond to his phone calls and voicemail messages. So tax court says, okay, let's look at this. Settlement officer sent 2 separate letters to the petitioner and counsel. And this is really important. Petitioner does not deny having received both the letters. And they say, well, look, the letters to the lawyer were sent to his address that he has right now. And the lawyer doesn't deny receiving the March 15, that sort of last chance letter where it says March 29 is your deadline. Now, I don't know. Maybe the lawyer didn't get it. Maybe the IRS didn't send it out. This sort of stuff does not have to be done by, personal delivery or FedEx or certified mail, that type of thing. So a lesson from this is even if you have a lawyer or a CPA or an enrolled agent representing you before the IRS, if you get a letter with the hearing date, you need to make sure your lawyer knows about that. Say, hey, did you get this letter? Because I just got this letter today. It says, here's the deadline. Just to make sure everybody's on the same page. And then the court says, well, look, the petitioner called the settlement officer on March 29. Remember, that's the deadline to submit the documents. Called and tried to add his lawyer, but couldn't add. So, again, whether fair or not, I'm just telling you what the court says here. Petitioner and his counsel have only themselves to blame for the attorney's failure to join that call and for their mutual failure to communicate with the settlement officer subsequently. Petitioner was clearly aware of his responsibility to provide financial information to the settlement officer, but he repeatedly neglected to provide anything. Given this track record, and this is important, the IRS does look at this. In other words, are you trying to do your best, or are you kind of blowing past deadlines and ignoring things they take that into account. So the court says did not abuse his discretion in closing the case on March 30. And then we have, going back to what the taxpayer said, is he wanted an offer in compromise or an installment agreement, but he didn't supply any of the required forms or necessary financial information. So the court says we've repeatedly held that it's not an abuse of discretion for the appeals officer, the settlement officer, to reject collection alternatives and sustain collection action, whereas here the taxpayer has failed after being given repeated opportunities to supply the necessary information. Point is, I don't care if it's a lawsuit against a debt collector, a trucking company, whoever it is, when there are deadlines, you've got to meet the deadlines. And they're not always convenient, and sometimes we have to ask for more time, and sometimes we have to stay up all night, But the point is, you've got to meet those deadlines. And then the court says, well, look, even if we ignore all that, you haven't filed your taxes for several post-2006 tax years. And if you are not in compliance with having filed your taxes, every year you're supposed to file them, then any proposed collection alternative, offer in compromise, installment agreement, can be rejected for that reason alone. So before you file an offer in compromise, before you request an installment agreement, you need to make sure that you're up to date. Now, there's some strategies involved with this, exactly which years need to be filed. Sometimes there's a strategy, and do you file your state taxes first and start working through those payment plans, and that may make it more advantageous for you to then do something with the IRS. But the bottom line is, before you go to the IRS saying, hey, give me an installment agreement, an offer in compromise, you need to be in compliance. And so they say, look, there's no abuse, so we're going to grant summary judgment and affirm the action. And then they point out, and I'll say this about the IRS. I mean, obviously the IRS is kind of scary, right? It's like you get a notice from them, but they're not as bad as they could be. And they do have a job to do, which is to collect taxes, and nobody particularly wants to pay taxes. But I like this. We note petitioners free to submit to the IRS at any time for its consideration and possible acceptance a collection alternative in the form of an offer in compromise or installment agreement supported by necessary financial information. So they're not saying you are forever barred from doing that. They're saying you can do it, just submit the right paperwork, the right forms. And they don't say it here, but they would also say, make sure you're in compliance with filing your taxes. Because you can't go to the IRS and say, cut me some slack for all those years in the past. Oh, and by the way, I haven't filed my taxes for 4 years. They're going to say, absolutely not. And so we've got some footnotes through here, and there's nothing particularly important about this. We do have this one footnote that just says, cannot now challenge his underlying tax liability. Well, why? Because he received a notice of deficiency for those years. So point is that he's stuck with that tax liability, so he either needs to get an installment agreement or an offer in compromise. And just as a reminder, the offer in compromise is really 3 types. One, very exceptional, and that's where you say, I owe it and I have the ability to pay it, but let me not pay the full amount. Typically, somebody's 90 years old, they're disabled, they maybe have all their money is in a handicap accessible house or whatever it might be, where basically you're going to the IRS saying, it would just feel wrong. Just in your core, you would feel wrong about taking this person's money, at least all the money. So very rare that happens. The doubt to liability is, hey, there's a serious disagreement about whether we really owe these taxes. And then there's a doubt as to collectability, which is, okay, can the IRS really collect this? Can the person really afford this? Okay. And so we've done kind of, not so much the first one, but mainly the collectability and the doubt to liability, where we say, hey, there is a question about whether we really owe this. Or on the collectability, and I've used this example before, where they say, hey, we want this money from this person, but there's a trust set up, but that person doesn't have the ability to go get the money. So it's what's called an irrevocable trust. And depending on how it's set up, that can sometimes present some challenges to the IRS to getting the money. And so there can be a doubt about that. And that's just where you compromise and you work things out where you say, okay, everybody can live with this decision. And so the bottom line in this case is you got to file the forms, you got to follow the rules, follow the deadlines, the dates, and then you have a shot. It's no guarantee that you'll win, but at least you have the potential to win. If you don't follow the rules, don't meet the deadlines, and certainly don't file your taxes, then you really have no shot at getting, particularly an offer in compromise. So anyway, hope that that's helpful to you, and I will catch you guys in the next video. Thanks. Bye.